Hello, friends. So, we were doing chapter 2 of the Indian Contract Act 1872, and I actually tried to do or recorded videos regarding other topics like story reading and reviews. So, I'm also going to do some movie reviews and some OTT. Actually, OTT, I don't have the subscription right now. My subscription ended, so I cannot do OTT new release reviews. But I'm going to do, the important ones, or you can say the popular ones. Those I'll try to review when I take the subscription next. But movie reviews I can do, and story reading, some just normal story reading, and review along with it. That I'm going to do. But right now, I think I'm just recording this. I don't know whether it will be my next video after the study video, or next to next I'll post it. I'm just recording it and I'll post it accordingly. I haven't posted any after the two videos that I publicly posted. So, study videos. So, this is my another study video that I'm recording. It's chapter 2 of the Indian Contract Act of contracts, voidable contracts, and void agreements. I'll try to keep it short as possible. So, let's dive in. So, first, there are 10 to from 10, starting from section 10 to and ending in section 30. That is what is embodied in chapter 2 of the Indian Contract Act. There are in total 20 sections, and I do this because it makes me feel good, not because I'm imparting so much of knowledge to anyone, but I think it's mainly for entertainment for me, because I like to do this kind of videos. And if anyone watches it and then likes it, so it will be an entertainment for them or enjoyment for them. So yeah, let's dive in. So section 10, what agreements are contracts? So first, the bare act reading I'm doing. All agreements are contracts if they are made by free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Nothing herein contained shall affect any law in force in India, and not hereby expressly repealed, by which any contract is required to be made in writing or in presence of witnesses, or any law relating to registration of documents. So what is said here is actually the detailed version of what we uh, understood by reading the definitions, that is from A to H, I guess, in the first chapter, in section 2 of preliminary. And from there only we derive the content of whatever is in here in section 10. So that is what they're saying, that all agreements are not contracts. That is what we read, that agreements that are actually enforceable by law are contracts, and those agreements that are not enforceable by law, those are not contracts. So the enforceability factor, how do we weigh it? We weigh it by consideration, whether the consideration is lawful or not, whether it is even there, the subject matter, whether it is lawful or not, the parties, whether they are competent to contract or not, the competency is there, and whether all the conditions of the offer are complied with by the acceptor in in unconditional manner, and after that whether everything has gone accordingly, then only the agreements turn into contracts. So that is what is given here. And yeah, so what is, and another thing is added is, nothing that is contained in here shall not affect any law which is forced in India, and that is not expressly repealed, by which any contract is required to be made in writing or in presence of witnesses, or any law relating to registration of documents. So Some contracts requires witnesses, some contracts require registration. So this contract act would not disturb those laws. So those that are there will be there. These are not in this provision itself. Section 10 is not contradictory to those sections that will be found anywhere else in any other enactments. So there are some comments, that is breach of statutory provision. Railway invited tenders for the supply of jaggery to the railway grain shops. The respondent submitted his tender for the supply of 14,000 imperial mons of cane jaggery, that is cane sugar cane, uh, derivation derived from sugar cane. So during the month of February and March, and the tender was accepted by letter. So far, the offer of a supply of a definite quantity of jaggery required a specified period at a certain rate, and the acceptance of the offer would constitute an agreement, but would fall short of amounting to a legal contract, inasmuch as the date of delivery of the jaggery was not specified. Once the order is placed for such supply on such, I'm just reading it now, it's pretty simple and pretty literal, so we won't need much explanation here, I guess. Once the order is placed for such supply on such dates, so dates are given, that order amounts to a binding contract, making it incumbent on the respondent to supply jaggery in accordance with the jaggery or anything, whatever the subject matter we are saying, in accordance with the terms of the order, and also making it incumbent on the DY General Manager to accept the delivery in pursuance of that order. So this is a case law, Union of India versus Madala Thataya. It's a 1964 case law. So what has been given here is the requirements. So railway has given a tender for the supply of some goods to the railway grain shops, and the respondent, he submitted his tender saying that he will supply 14,000 of mons, imperial mons. That is how they measured the quantity of the grain that they are supplying during the month of this month, um, February and March, they have said any month. And this tender was accepted by the, so railway gave an offer, an open offer to the world, and this was accepted by our respondent, who again submitted another tender saying that, yeah, I'll give this much grain in this month, and which was again accepted by the, so we are seeing a reciprocal promise here. So this was again accepted by a letter by the railway authorities. So far, the offer of a supply of a definite quantity during a specified period or certain date and acceptance of the offer. So this would, so both of them have accepted their offer. So they are saying that this has resulted in an agreement, because we have seen that promises results in reciprocal promises, and reciprocal promises gives rise to an agreement. But this won't be a legal contract till now, at this stage, inasmuch as the date of delivery of jaggery was not specified. So they said that February and March will give it, but they haven't said the date, when they will give it and which date. So once the order is placed for such supply on such dates, the order amounts to a binding contract. So when it becomes a binding contract, till this much stage it remains an agreement. But when it becomes a binding contract, when the order is actually placed. So the railway got the letter and the railway placed the order. Yes, February and March you said. So 10th of March and 9th of February you will give me this amount and this much amount, and say they give the consideration, they deposit the money. So now they have given the consideration, and they have asked for the amount on the specific dates. So now it becomes a contract. So now they are bound to, the respondents are bound to supply the amount of jaggery that has to be, or the amount of anything, the grains that has to be supplied to them. So that is what is given here in Madala Tathaitha. So the order itself, after they have, the railway authorities have accepted the letter, then they are placing the order that on 9th of February and 10th of March you give me the supply. That order itself amounts to a binding contract, whether they give the consideration or not. That is what was held in Union of India case. So then we move on to letter of intent. A letter of intent merely indicates a party's intention to enter into a contract with other party in the future. So letter of intent is actually expressing the intention that yeah, someday I will enter into a contract with you, but they have not yet done so. It's a prelude to the contract. However, a letter of intent may be construed a letter of acceptance if such intention is evident from its terms. It can be construed as a letter of acceptance when the letter of intent say, I say to my whoever, I say to the next person that today is what? Today is October, in November first week. So I say that at the midweek of November, I will supply you some grains. And by another letter, he says that. So yeah, so I see him. I'll give him the. I mean that amounts to an offer. And say by another letter, my friend also or the next person also writes to me that yes, please do it. I will graciously accept your grains and then give you the money at that time. So that is that his letter is also a letter of intent, but his letter is kind of a letter of acceptance of the offer that I made. It might not be enforceable by law, but it does expresses an intention of acceptance. Dresser Rand SA versus Bindal Agrochem Limited, AIR 2006. What agreements are contracts? If entering into a contract containing prescribed terms and conditions is a must under the statute, then that contract becomes a statutory contract. If contract incorporates certain terms and conditions in it which are statutory, then the said contract to that extent is statutory. So whatever is related to the statute is stated in the contract, say the sections, whatever that is adhering to the statutes, the enactments, the laws, that part remains statutory. Whatever the facts that are stated, yeah, and this date you give me this much amount of grains, or this much amount of money, that is factual. So they have just differentiated the parts in a contract or the contents of the contract, like the contents of this enactment is separated into chapters. This has been held in Thermal Power Limited versus State of Madhya Pradesh, year 2000. In order to constitute a contract, both the parties must consent to the agreement. So consent is free consent. It's a very important thing. So consent must be free. It must not be made by undue influence, coercion, or fraud or misrepresentation or by mistake. It must be a free consent. So this has been, then only the contract will be, agreement will turn into a contract. So this has been held in Steel Authority of India Limited versus Salem Stainless Steel Suppliers, year 1994. Then the next one is, a person who by reason of infancy is incompetent to contract cannot make a contract within the meaning of this act. So an infant's contract is void. This we will read in what are void contracts there. So if the guardian makes it on behalf of the infant, then it becomes valid. Although a ratification clause is there, the infant can become, the a major, that is 18 years of age, which is required for a contract, and then can ratify the contract, whether he wants to accept it or he wants to rescind it. That clause is sometimes there. So yeah, the question whether a contract is void or voidable presupposes the existence of a contract within the meaning of the act and cannot arise in the case of an infant. So in Mohori Bibi versus Dharmadas Ghosh is a very important case where I don't remember properly, but probably a child was given some food or some property, I guess. Sorry, I'm just all jumbled up. I don't remember the case, just the structure of it. An infant was given, I think, some benefits by a person, and then he had to be paid back for the benefits that he had made. So then it was held by the court that the the benefit that he had supplied to the infant, that for that the payment that he will get, that cannot be a contract. This whole matter, because he's an infant. When you are supplying something to the infant, you cannot make a contract with him. Yes, I'm supplying you this much of food or this much of what to say, anything, house building materials or something, and you give me the money. So you cannot do that with the. So that is what they did. So yeah, there is no contract. The contract itself, the thing itself is void. He can be later given. Yeah, but in this case, Mohorabi versus Dharmodas Ghosh, it was held that the contract, there was no contract only for the benefits that he has made to the infant. So then what agreements are not contract? Agreements subject to ratification by others who are not parties to it is not a conclusive contract. So whenever I make a contract with the next person, an agreement enforceable by law then becomes a contract. We cannot tell that this is a contract. Say I make an agreement with the next person that others, if what to say, ratification by others. Yeah, if A and B says that it's okay, then only I will supply you 10 months of grain, and then you can give me the money. So then I made a contract on condition. I made the offer on the condition that ratification, it has to be ratified by A or B. Or say I made an offer that I will supply you 10 months of grain. You now give me the money. You will give me the money for it. So then while accepting it, he says that yeah, I will give you the money for it, but if my parents agree to that. If my parents doesn't agree to that, then I cannot give you the money. So then of course he's a major. Then it's not a proper contract according to MV Shankar Bhatt versus Claude Pinto, deceased 2003. So then we move on to section 11, who are competent to contract. Now we move on to the parties to the contract who can contract. So not every person can make a contract. Every person can make an agreement, but every person, if those agreements will not be enforceable by law. To become enforceable by law, those persons that they are making, that first there will have to be minimum two parties. One party cannot make a contract. There has to be minimum two parties, and those two parties, one the offerer and one the acceptor, has to be major first. They cannot be minors or infants, and their consent has to be free. It should not be coerced or influenced or by fraud, by mistake, or by misrepresentation, something like that. They should be of sound mind while making the contract. They cannot say some people are of, say one party is of unsound mind, then the contract made in that time becomes void. But whenever he becomes, say after bouts of insanity, he becomes sane at some points of time, then he makes a contract, then it becomes valid. So it's like that. And next, agreements also should not be. So these are the competency of the parties. So these are, we will read section 11. It starts, every person is competent to contract who is of age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So who cannot contract, we can derive from the three categories we find of people. That is, minor people cannot contract, people of unsound mind cannot make the contract, and people who are already disqualified from contracting by any law, say if they are convicted or they are restrained in some other way on a bail, something like that, say restrained by law, any kind of law, so they cannot make a contract. So comments will read, minors contract of service. Contract of marriage entered into by a father for the benefit of his minor child is not void for want of consideration, unlike a contract of service by a minor, which is a contract of service entered into by a father on behalf of the minor. I think, I hope I'm not dragging this video too long. I'm trying to keep it as short as possible. Okay, so we're reading the comments of section 11. I think I misspelled something. I said a contract of service entered into by the father, but it is contract of marriage entered into by a father. So if a father enters into a contract of marriage on behalf of his minor child, it is not void for want of consideration. Agreements in restraint of marriage is void. But if a father enters into an agreement of marriage, contract of marriage, for the benefit of his child, it's very much valid. And but if the father enters into a contract of service on behalf of the minor, say, yeah, my child will work here, that becomes completely void. That is not enforceable because a child is not allowed to work in our country unless he reaches the age of majority or a certain age to be that is stated in labor law, that is for employment in factories and also under the constitution. So that is what is stated in Rajrani versus Premadeep, AIN 1949. Then I move on to minor's contract is void. So where a mortgage was made by a minor, oh yeah, that is Mohorivi versus Dharmadas goes. They have given the case law here. Let's see if it matches. No, it doesn't matches mine. I just said something of that kind, but here is it, where a mortgage was made by a minor and the money lender who had advanced money to the minor. Yeah, I said some benefits. So it was money that he had given to the minor. On the security of the mortgage, sued the minor on the strength of the contract. It is held having regards to section 2, 10, and 11 of the Contract Act that the Act makes it essential that the contracting parties should be competent to contract and that the minor's contract is void. So 1903, Mohrivi versus Dharmadas goes. So there was a mortgage. The minor has made given a mortgage, say of some things, and in return of it, on his name, money was taken, amount of money, and then the money lender advanced it on the security of the mortgage. So after some time, now he asked for the money back, the on the strength of the mortgage. So the court held that there is no contract. So how can he? There was, because it was made on in the minor's name and it becomes completely void. So how can he get his money back? So it's a very old case law. So then we move on to section 12. What is a sound mind for the purpose of contracting? A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it he is capable of understanding it. That we see the minors contract, some of the minors contract could be, valid if they are ratified once they grow up, once they become major. I mean, 18 years, that which is competent to contract, but not in this case. In other cases, there are other cases like that where the minor can ratify the benefits that is given to him and then pay his or do his part of contract. That is also there and very much valid. That makes a very much binding and valid contract. So then we move on to section 12. What is a sound mind for the purpose of contracting? A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it he is capable of understanding it and of forming a rational judgment as to its effect upon his interests. So when can a person is said to be sound mind? So I said that if the due to reason of unsoundness the contract becomes void. So what is soundness? You can say soundness is when a person understands with his rationality or prudence that, yeah, I'm doing this, I'm entering into this, I'm giving this, I'm getting this, and I agree to it as it is. So that then only he will be said to be of sound mind for the purpose of contracting, or prudent. So he understands his interests very properly. A person who is usually of unsound mind but occasionally of sound mind may make a contract when is of sound mind. That is bouts of insanity, I said. So whenever he is not insane, he can make it. But a person who is usually of sound mind, so I'm usually of say any person who is usually every time he's completely okay, but at one occasion he fell completely ill and became insane. So if at that time he makes a contract, then it becomes void. Okay, so illustrations: a patient in a lunatic asylum who at intervals of sound mind may make a contract during those intervals. So a person in lunatic asylum is not barred from contracting, although he may do so when he remains okay in a recovered state. A sane man who becomes, due to fever, delirious and fainting, or who is very much drunk and he cannot understand the terms of the contract due to his deliriousness, or form a rational judgment as to, so that has to be measured by the court, to what capacity he is. He cannot form a rational judgment. At some amount, a drunken man can be held liable for his mistakes, or can be made liable for, you know specific performance, but at some point he cannot. Or a person who is delirious from fever, he cannot be considered to be of in a proper mindset to make a contract, because he won't understand his interests, what he's giving and what he's getting at that state, due to his drunkenness or due to his deliriousness. Okay, so then consent defined, section 13. What is consent? So two or more persons are said to consent when they agree upon the same thing in the same sense, not same time. They can do so, at different days or different times. The offer is made in one day, acceptance is made in some other day. It doesn't have to be in the same day, but in the same sense. He understands the offer as it is and agrees to it. And same thing, say I agree to sell this house, say a house uh, which is thatched, but my acceptor thinks that it's the brick house, or brick house that is situated just 2 blocks behind it. So then he's not agreeing on the same thing or in the same sense. So yeah, it becomes void. Such contracts becomes void because the consent is not, there's no consent. What is free consent? So free consent is said to be free when it is not caused by, so it's a kind of negative way the thing is given, what is not to be done in that way. So coercion, undue influence, fraud, misrepresentation, mistake. So if these 5 things are there, then we'll say that consent is not free. So in that case, when coercion is there, when undue influence is there, when fraud is there and misrepresentation is there, we can say the contract becomes voidable. That is, it can be either it can be rescinded or it can be accepted by any of the parties. And not any of the parties, at who is affected by the coercion, or who is affected by the undue influence, or who is affected. The affected party can only rescind or accept the contract. And mistake, in case of mistake, it either becomes void or becomes valid. There is no case of voidable in case of mistake as to law, foreign law, or mistake as to Indian law, or mistake as to matter of fact. And then what is said? Consent is said to be so caused when it would not have been given, but for the existence of such coercion, undue influence, fraud. That is what is given in a positive way here. Same thing is written. So then we move on to section 15, coercion defined. So what is coercion? Coercion is the committing or threatening to commit any act forbidden by the IPC, or Okay, so my device is heating up a bit. I think, yeah, a lot bit. It's heating up. So I think I'll, from section 15, so we'll cover till section 15, from 10 to 15, just 5, not much. So from 15 to 30, we'll do in the next video or in the next recording. I'll put it together so it might not seem like that. Yeah. So, toodles.